Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigator series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Hi, I'm Steve Weisbrot. Welcome to another edition of Angeion's Leading Litigator video series. Today it's our pleasure to have the founding partner of Stueve Siegel, Norm Siegel, joining us here today. Norm, thanks so much for being here.
Steve, thank you. This is truly an honor. I've watched all or nearly all of the Leading Litigator series and learned something from all of them. And you all have been truly innovative in what you've done and learned a lot both from you and the series.
Oh, thank you very much. It's very nice and nice to say, and obviously welcome to hear. So, and I know that our viewers are about to learn a lot from you. One of the ways that I've always sort of thought of you is not just as a complex litigation attorney, but as an attorney with a particular expertise and depth of experience in the data breach context. I think data breaches in particular on everyone's mind because we hear about them every day, but also because there's been some particularly egregious and large-scale data breaches that have occurred recently. My question for you is, as these become more ubiquitous, are we going to continue to see litigation surrounding each and every one, or is there going to be a tipping point at some point where people are like, you know what, the data's out there? What do you think? Where are we going with this?
Right. So lots of questions in there. I think, yeah. Well, I think I think ultimately you will see legislation. So, sort of taking the long view first, I think at the end of the day, Congress will have to pass legislation that basically provides a European structure to how companies treat data security in the United States. Europe is way far out in front of the United States in terms of standards, data security guidelines, and the United States is not. There have been numerous efforts to pass legislation at the federal level, all of which have not gained traction. And so what you're left with is a patchwork of states.
California leading the way.
California leading the way, but others too. But it's a patchwork of different rules, regulations, notice requirements if there is a breach, which I think is probably not ideal for U.S. corporations trying to handle these issues, and really does create confusion in the marketplace. But I think in the nearer term, to answer your question, I do think these cases will continue to be brought. You see data breaches in many kinds of contexts, and sometimes the defendant is, their conduct is more egregious than others. So you have everything from phishing efforts where a accounting person mistakenly sends out the confidential personal information of employees, including social security numbers, in response to an email that they think is legitimate, to just larger, very egregious cases like we've seen in Home Depot, Equifax, and others.
Sure. So I want to go back to something you said, talking about the long view. If this becomes a regulatory solution, if it's a GDPR US version,
Right.
My concern is, and I'm sure everyone's very interested in what my concern is that does the federal government have the bandwidth to bring an action for all of these, because there's just so many, and even in GDPR, I mean, I've been following it very closely for a variety of personal and professional reasons. They're really cherry picking what they go after, and it doesn't really provide a viable solution to vindicate consumers' rights if it were regulatory.
So I don't view the regulatory regime as a mechanism of enforcement necessarily. I do think it's important from a standard standpoint. I think today we have negligence, which is a great tool. The common law of negligence applies in these cases. Did this corporation meet its standard of care in protecting confidential data? That typically is a concept that U.S. courts understand, and as lawyers we can litigate around the concept of duty and breach and damage. So I view the regime more as establishing standards. And my view has always been, and I'm not suggesting that is a universal view on our side of the bar here, but if we have a federal standard that is real, that is GDPR-like, that is firm, that sets a high bar for data security, I would not be opposed to some level of protection for companies that meet that standard. But the standard has to be real. It has to be firm. It has to be something like GDPR.
No, that absolutely makes sense. You mentioned a couple of cases I know that you've worked on. Do you want to talk about any of those particular cases, or maybe talk about general learning experiences you had litigating those large data breach cases?
Well, it's interesting. It's been quite a trend. I actually looked just yesterday about when we got into the data breach business. Really began with Target, which is now more than 5 years ago. Wow. And so Target was one of the initial larger retailers that suffered a large data breach. And the litigation from that, I think, really began the modern trend where you have a very aggressively litigated motion to dismiss that addressed many of the issues that are still being grappled with today, including standing. And Judge Magnuson and Target kind of set the initial bar, and then obviously there's been dozens of other cases, including large ones like Anthem, followed by others in front of Judge Koh, and of course Judge Thrash with both Home Depot and now Equifax, dealing with these large issues that I think are becoming, you can now see a trend over the last 5 years.
A trend but not a consensus, maybe.
A trend but not a consensus. I think we're nearing consensus on some of these key issues like standing.
Right.
I think the trend, and perhaps sooner or later it will be considered a consensus, is to have a broader view of standing with respect to the injury component of standing. Defendants have taken the position that always baffled me, that the theft of your most sensitive personal information is not an injury. And they have gotten some traction, at least in the early years of the data breach wars, with that argument. But I do think that now that the appellate courts have begun to look at these issues, that the trend is certainly in the direction of a broader view of standing with respect to that injury. And I think courts are more and more sensitive to the proposition that your most sensitive personal information, your social security number, your passport number, your health information, is the type of information that once stolen is an injury.
Yeah, absolutely. So Norm, like I said, I primarily recently associate you with data breach cases, but you have no dearth of experience as it relates to complex class actions. And in fact, you and your firm have tried probably more class actions than anyone, or at least on the same page as the most prolific trial class action attorneys. You want to just take a few minutes and tell our viewers about that experience? Because I think so few of these cases are tried that everyone likes to hear some war stories.
Yeah, sure. Well, I do think that our firm history probably plays some role in that. We were all complex litigators 20 years ago when we decided to start this firm with a couple of lawyers, and then obviously we've grown quite a bit since then. But as complex, just business tort lawyers, you end up trying a lot of cases. And the class action practice, which has always been roughly a third of what we do, when we started doing that really in earnest 15 years ago, we always had an eye towards trying cases, including those class action cases. Right. So we came to the practice, to the class action bar, from a perspective that when you initiate these cases, you have to always have an eye towards trial. And I think over time, I do think there's a trend to trying more class action cases. In the last 5 or 6 years, we've tried 3 of them to verdict, and cases against Tyson over shift workers and donning and doffing in an FLSA case.
Sure, I remember that case.
Yeah, the Syngenta modified corn litigation in the District of Kansas, big MDL there with a $200 million verdict for Kansas farmers. And then most recently, I tried to verdict a case against State Farm involving overcharges for life insurance policies. And I think the view of our firm is that these trials are good. They educate the federal judiciary that we as class action lawyers are not just filing these cases hoping to extract a settlement, that we are prepared to take the case through trial, and that it's possible, that these judges, you work with these judges to educate them about how we can get from beginning of case through jury verdict, and the fact that it's brought under Rule 23 doesn't materially change the process for them.
So obviously you just addressed how judges view firms that are likely to take cases to trial. My question is really, how do defense counsel and frankly their clients evaluate that? Is there a premium put on the value of the case because they know you're willing to go to the mat?
The short answer is yes. I think anytime we show up in a case, our view, we hope, is that the defense counsel is advising their client that these folks are potentially in it for the long haul through trial. We are not in it for a hope at a quick settlement, but it is used to leverage a settlement, right? So if you have a willingness and a proficiency for trial, you have jury verdicts that you can point to that show your success at trial. I do think it helps in the negotiating room as well. I do imagine it would, yeah. And I do think defense counsel are also pushing these cases further along. We track every case we've done over the last 20 or so years. The time it takes to resolve a case, either through settlement or trial, probably has gone from about 2 years to 3 years on average. And so I do think the defendants are pushing these cases out further. They have their own economic issues in these defense firms that perhaps contribute to that. But the process is definitely taking longer, and I think is bending towards trial more frequently now.
It's interesting. You just said something that really intrigued me. You track all of your cases. It doesn't seem to me that a lot of plaintiffs' counsel, and I'm certainly not casting aspersions on plaintiffs' counsel, but are that sophisticated in using data and sort of running their firm more similarly to the way a defense firm is run. And it sounds to me from what you just said that you're pretty unique. Can you talk about that a little bit and what other measures maybe you're using that we wouldn't expect?
Sure. Well, the time one is right at the top of the list.
Okay.
So I was a partner at a large defense firm, the firm now known as Denton's. Sure. Obviously, in that setting, you're keeping all of your time. When we started our firm in 2001, we committed to keeping all our time regardless of the type of case. We did some hourly work then and do some hourly work now. Obviously, we keep our time there, but we've also kept our time on every single matter we've ever opened in the firm over the last 19 years. And what that has allowed us to do is to track our return on every case and types of cases. So we can look and we classify our cases. We can look at our return on business tort cases. We can look at our return on Fair Labor Standards Act cases. We can look at our return on our time on straight consumer class action cases. We have a mass tort practice. We have personal injury cases. And we're able to see over time how our time is best spent. And that time, both from our staff time, associate time, partner time, the senior partner time, we can see really where the best use of our time is from a straight just business proposition. What can we be doing with our time that is most valuable to the firm?
So that's fantastic. What's the aphorism? Without data, it's just an opinion?
Right.
So how often do you actively review the data and have sort of management team meetings about the direction of the firm?
So we look at it sort of in real time. Everybody keeps contemporaneous time for all cases. And then we probably look at it quarterly at some level, and then at the end of every year, we look both at the year and then against the aggregate data from day one of our firm.
That's great. It's really fascinating because, I really, like I said, I don't feel like enough plaintiffs' firms are using data and determining the right direction for the firm. Is there anything else before we close up that your firm does specific to law firm management that you think our viewers might benefit from?
So the one question I repeatedly get from lawyers that are stepping out to start their new firms is, what is the one thing you would do or wouldn't do to make your firm successful? And the answer is always the same. It's create a business environment whereby everybody takes part of the risk and everybody participates in the reward. It's important to have both parts of that, right? So we hired people from day one with the understanding that they will have a base salary, and then when the firm's successful, they're bonused. And that's from obviously the partners all the way down through associates, staff, to our receptionist. When we have a good day, they have a good day.
That's great. Norm, this was excellent. Thank you so much for joining us. I really enjoyed it.
Steve, so did I. Really enjoyed it, and hopefully somebody will learn from this the way I've learned from many of the lawyers before me.
Thanks, and I'm sure they will.